Hey, Paul here, and in this video we're going to talk about how getting a guardian appointed for somebody who's reached the age of majority is really a harsh matter on everybody involved. Okay, so I think most people underestimate how difficult and intrusive most people around the United States call this a guardianship proceeding. In my state of Louisiana, it's often called an interdiction proceeding. I'll probably use both of those terms throughout the video. And a lot of people mistakenly think that it's just, it's no big deal. You get a judge to sign something, it's done. So, I've seen people come into the office and say, my dad's incapacitated, he has Alzheimer's, his house needs to be sold, he's not able to do it, he had a stroke, he has Alzheimer's, whatever. He doesn't really understand what he's doing. I heard we needed to get an interdiction or a guardianship proceeding. And sometimes they'll throw in something like, my next door neighbor, her brother's wife is a judge. Can I give some paperwork to my neighbor and she'll get the judge to sign it, and that way we'll have that interdiction and then we can sell my dad's house. Well, that's just misinformation. It's a joke. It is a very lengthy, expensive, many rules must be followed. And we're going to talk a little bit about that in this video today. It's such a harsh proceeding. One judge wrote, and really I couldn't state it any more accurately, one judge in an interdiction court proceeding in our state of Louisiana wrote that a judgment of interdiction is, in the final analysis, a pronouncement of civil death without the dubious advantage of an inscription thereof on a tombstone. So when there's a guardianship or an interdiction, the interdict, or in some states they call it the defendant or the ward, the interdict, the person whose capacity is being taken away from them, they lose their capacity to make an affidavit, to sign a contract. They lose control over where they will live, how they'll spend their money, all medical conditions, and virtually they'll lose control over every aspect of their life. Now, there are some less restrictive means that we try to see if these less restrictive means can accomplish what's attempting to be accomplished without the whole interdiction proceeding. So a few of those, and just let me give you a couple of examples of when an interdiction might be necessary. It might be someone got into an automobile accident, they have a brain injury. Might be someone has cognitive disability, Alzheimer's, dementia, maybe they had a stroke, and they just, they don't have that mental or physical makeup to be able to make their own decisions. So, they can't handle their money, they can't pay their bills. So that's a typical scenario, and we often see that either with the elderly or with the severely injured. There's another scenario where we often see an interdiction is when someone they appear to have, the ability to manage themselves and their property, but they're a high risk, and that's my word, a high risk for injuring themselves. Give you an example. Dealt with one in the courts one time when Mom was really successfully getting scammed. People were contacting this mom, telling her she had won the lottery. Oh, you'll get your millions of dollars as soon as you send in $3,000 to this scenario so that the taxes can be paid so we can send you your millions. Oh, thank you for the $3,000. We just found out we need another $5,000. Mom just keeps writing those checks. She thinks she's a winner. She's convinced she's not being scammed, but she's throwing away all of her money. So sometimes we have to get people interdicted even when they don't consent to it, and that's a real tough one. So some of the less restrictive means, less restrictive than an interdiction or a guardianship proceeding, are the time-limited civil commitment for mental illness or substance abuse. That's one. Another less restrictive means is the power of attorney. That doesn't solve all of the problems all of the time, because if mom gives daughter power of attorney, then yes, daughter can transact for mom, but at any time mom can go transact for herself, and mom can even revoke the power of attorney to the daughter. So by mom giving daughter power of attorney, that doesn't solve the problem of mom, quite frankly, quote, doing something stupid. Now, regarding someone's finances, I guess there's always the opportunity to create a trust. But in our example with mom and daughter, mom would have to voluntarily agree to allow her finances to be transferred into a trust. It'd have to be some type of irrevocable trust that mom couldn't change, and mom would have to designate daughter or someone else as the trustee of that trust. We often find that people often don't want to voluntarily give up that control over their money. So sometimes a less restrictive means is not possible, so we have to go the interdiction route. In our state, we have really, I'm gonna call it two types of interdictions. There's the full interdiction and there's the limited interdiction. And let me just kind of throw a little law out at you. Hate to quote the law too much, but I like to get it right. So we have something called a full interdiction. So it says a court may order the full interdiction of a natural person of the age of majority who, due to an infirmity, is unable consistently to make reasoned decisions regarding the care of his person and property, or to communicate those decisions, and whose interests cannot be protected by less restrictive means. So that's the full interdiction. That's where court hearings, which we'll get into in a minute, judge signs an order. Sorry, dude, you can never transact for yourself forever. So that's a pretty big deal. And then we also have the limited interdiction. Maybe sometimes people are capable of rationally making their own medical decisions, but they're not capable of handling their money. So there could be many circumstances where a less restrictive limited interdiction may be necessary or may be helpful. So we have a provision that says a court may order the limited interdiction, again instead of full interdiction, of a natural person of the age of majority who, due to an infirmity, is unable consistently to make reasoned decisions regarding the care of his person or property, or any aspect of either, or to communicate those decisions, and whose interests cannot be protected by less restrictive means. Okay, so two kinds, full interdiction. We do full when we have to. If we can get away with a limited, we'll do a limited. Now, I just want to give you a couple of the procedural steps. Maybe I'll demonstrate maybe one of 5 of the procedural steps, just to give you an idea of how much is involved, and you can't just get the friend of a friend judge to sign a piece of paper and voila, you've got an interdiction and a person's legal capacity has been taken away from themselves. So just to give you an idea of the very step 1 of an interdiction or guardianship proceeding, and these are state rules. Check with your state to see how your rules may vary. But here in Louisiana, just the petition, which again, maybe this is something that a son has to do to get his father interdicted because his father doesn't have capacity. Maybe a parent is doing it for a child who was in an accident and had some brain damage. Sometimes a husband has to do it for a wife or vice versa. So just the contents of the petition have to state with particularity the name, domicile, age, and current address of the petitioner and his relationship to the defendant. Name, domicile, age, and current address of the defendant, and reasons why interdiction is necessary, including a brief description of the nature and extent of the alleged infirmities of the defendant. If the full interdiction is requested, reasons why limited interdiction is inappropriate. And then you have to put the names of many, many different people in that petition. One of the reasons that you have to do that in another article of our procedural rules is that all of these peoples whose names must be in the petition, all of them must be sent a copy of the petition within 3 days after it's filed at the courthouse. So those people are the spouse, the adult children, if he didn't have adult children, the parents or the nearest relative, and then you have to include all the information out as to the proposed, what's called in our state, curator, or in your state it might be called the proposed guardian. So that's just step one. That's the petition, or typically kind of the initial pleadings of the lawsuit that is filed. And then it doesn't stop from there. So what you're going to start finding out is lots and lots of people need to be put on notice about this, and there's lots of protections in place to make sure that the person who is proposed to be interdicted gets adequate representation. So one of our rules is, yes, there's what's called personal service. I'm not an expert on personal service, but in general, the sheriff has to serve this lawsuit on the person who is proposed to be interdicted. And then there's a waiting game. Yes, that person that you're suing might be your parent or your child or some other relative. They have to have an attorney. So sometimes they'll get their own attorney. Sometimes they don't have the capacity. They live in a nursing home. They're not even aware. They were served with all of the papers, which is bad enough. They don't understand it. Of course, they don't go get an attorney. So then if 15 days passes and they do make no timely appearance through an attorney, then the person who filed the lawsuit has the responsibility to apply to have a judge appoint them an attorney. No, the person who filed the guardianship lawsuit cannot go select the attorney for the interdict. So a judge appoints a guardian for them. All this has considerable expense. So now that's just the very, very initial stages of this guardianship or interdiction proceeding. And then there's lots of other procedural requirements for the actual court hearing that's required, what a judge has to be satisfied with before a judge signs any judgment of interdiction, declaring the person incompetent, taking away all of their abilities to transact for themselves. And then lots of procedural requirements on having what's called a curator appointed, or in other states, a guardian appointed. And here in my state, there's both a curator and an under curator who watches over the curator, just so that there's all these checks and balances to make sure that whatever needs to take place that's in the best interest of the defendant is actually happening. And then there's all these accounting requirements that the curator has to fulfill. So my bottom line there, I don't want to bore you with a bunch of procedural requirements, but I'm trying to let you know that an attempt to get someone what's called interdicted or declared incompetent and get a guardian or a curator appointed for them through the court's proceeding, it's serious business. Many, many procedural steps, much ongoing reporting and accounting requirements. Most people find it, very, very expensive, and it often eats up the estate of this person who is proposed to be interdicted or is proposed to have a guardian appointed. Very time consuming. It always takes many months just to get to the first step of having them declared incompetent and have a guardian or curator appointed. Often it's very adversarial between the person who's trying to get someone declared incompetent and the person who is trying to retain their status of being able to contract for themselves. So it often tears families apart. So in most cases, this is often done as a last resort because there's just no alternative or no less restrictive means to make it easier to protect the interests of someone and make sure that the decisions that are made on behalf of that person, whether it's a financial, medical, or other decision, are in the best interest, of that person. So guardianship, interdiction, that's the deal there. Difficult proceedings. Make sure you obliterate the like button, or as we say, make sure you subscribe so you don't miss anything. We'll see you next time. I'm Paul Rabalais.